this video, I will explain what is an offer in contract law and key cases about it. This will help you get high grades in contract law exam. I'm Nini. I'm founder of Simple Studying. I have LLB and LLM degrees from City University of London. I got high D1 and first class grades when I was at law school, and then I built Simple Studying to help law students like you get high grades and build successful legal careers. We are building an AI-powered higher education tool. We help UK and US university students get high grades and build successful careers. This is our team on this picture. Why you should trust us? We have already over 25,000 law students in the UK studying on Simple Studying. Students who have got premium subscription and at least 6 hours of tutoring have reported to have got a first class in respective exams. We know exactly how to get a first class law degree after working with thousands of law students in the UK. First of all, I'd like to explain what is a contract. Contract is a legally binding agreement. The ingredients of contract is an offer, acceptance, consideration, and intention to create legal relations. Offer is a clear and unequivocal statement that is legally binding. It must be certain promise, clear, specific terms, and leave no room for negotiation. On the other hand, invitation to treat is invitation to make offers. Unlike offer, for invitation to treat, terms are not certain and there is room for negotiation. For example, see the case of Harvey versus Facey. Harvey sent a telegram to Facey stating, "Will you sell us bumper hole pen?" Telegraph, lowest cash price, answer paid. Facey replied, "Lowest price for bumper hole pen is £900. Harvey then said, "We agree to buy a bumper hole pen for the sum of £900 asked by you." It was held that there is no contract. The reason is because they never said that they would sell it to them. All they said is how much it was, but they never said clear terms on which they were willing to sell. Therefore, there was no valid offer. If there is no valid offer, there is no acceptance, and no contract was created. See the case of Gibson versus Manchester City Council, also a very important case you should learn. Defendant counsel prepared a flyer explaining how a council tenant could purchase the council house. The treasurer of the council wrote to the claimant, Mr. Gibson, that the council may be prepared to sell the house. He had to fill out a formal application and purchase the house afterwards if it was approved. Labour Party came into power and they discontinued this policy and they no longer allow people selling of council houses unless a legally binding contract was concluded. The issue in this case was whether or not there was a legally binding contract, so Mr. Gibson could buy the house. It was held that there was no contract because the treasurer only said that the council may be prepared to sell the house. They never made a valid offer. There was no clear terms and there was no clear offer for it to be legally binding. If there was no offer, there could not have been any acceptance. See the case of Storer versus Manchester City Council, also an important case about this topic. The principle that came out of this case is that an offer is an expression of willingness to contract on specified terms with the intention that it is binding once accepted. Therefore, offeror must be expressing willingness to enter into the contract on the specified terms. In this case, it was established that intention is less relevant in contract law. This basically means that it is more important to look at what has been said and done rather than the intention of the parties when it comes to assessing whether or not there was a valid offer. Standard situation that you should memorize. There are a few rules about things, whether it's an offer or an invitation to treat, and you should memorize them and cite the relevant cases in problem and essay questions about this topic. For example, Display of goods for sale is usually an invitation to treat. When you go to a shop and you see items on the shelves, this should be invitation to treat, according to the case of Fisher versus Bell. If you get this kind of situation and a problem question, you should state that it should be an invitation to treat, according to the case of Fisher versus Bell. Advertisements are also normally invitation to treat, according to the case of Partridge versus Crittenden. So all the advertisements you see should not be an offer, it should be an invitation to treat. The exception is unilateral contracts. In case of unilateral contracts, the advertisement is not an invitation to treat, but it's a valid offer. The case is Carlin versus Carbolic Smoke Ball, where £100 was offered to anyone who tried their medicine, the carbolic smoke ball, and still caught influenza. Somebody tried it, then sued the company and won the case because it was not an invitation to treat, but it was a valid offer because of the principle of unilateral contracts. Check out our contract law study module at Simple Studying to learn in more detail what is an offer, acceptance, and all the other details about contract law. We have all the relevant simple and condensed study materials you need for contract law to maximize your chances of getting a first class. You have two options. You can get a subscription and have access to all the main areas of law if you need it, or you can get contract law study module only and access it forever without recurring fees. Good luck!